Good morning. Hey, thank you for joining us for the Constangy Cyber Academy session. We're going to wait for about 30 seconds because we've got a number of people are logging in, and we're going to then get started with a tremendous session this morning regarding cyber claims and international perspective. And we're joined by some wonderful speakers from the London office of Pinsent Masons. All right, it looks like it's about almost 9:01 Pacific time, and want to thank you for joining us for Constangy Cyber Academy, a session on the international perspective of cyber claims. And this is John Hoare. I'm the chair of the cybersecurity and data privacy practice at Constangy, and I'm joined by one of my partners and vice chairs, Alyssa Watzman, and two tremendous partners from the London office of Pinsent Masons, Ellie Ledlam and Stuart Davey. Alyssa is a partner and chair of the Constangy Cyber Team, and she's located in Denver here in the United States. She's got extensive experience managing responses to data security incidents, having assisted thousands of clients over the past 8 years plus. She also excels in working with cyber insurance carriers and brokers on special programs to benefit their internal and external stakeholders. And if you're a broker or a carrier, you will know Alyssa because she's probably done some phenomenal things for you. She also provides clients with assistance in proactively planning with proactive data privacy and information security resources and training to bolster our compliance advisory practice team. We're also fortunate to be joined by Ellie Ledlam. She's a partner, as I mentioned, in the Pinsent Masons cyber team in London, and she specializes in cyber and post-breach regulatory investigations and litigation. She leads on cyber insurance matters for Pinsent Masons, and she recently won, yes, get this, recently won the Cyber Lawyer of the Year in Europe at the Intelligent Insurer Awards 2025. So a little applause for Ellie. She's well known internationally, and she's the Chief International Officer for the International Women's Cyber Alliance, a nonprofit seeking to elevate women in cyber. She's also a Back to Law ambassador for the Law Society of England and Wales, supporting career returners back into their legal career. So, Ellie, thank you so much for joining us this morning. And I also want to welcome your partner, Stuart Davey. He's also a partner in the Pinsent Masons cyber team in London. He assists clients in pre-breach readiness exercises and incident response. He also has a particular focus on the technology sector and businesses involved in industrial processes and organizations operating in critical national infrastructure. As an experienced litigator, he also specializes on litigation and regulatory action involving cyber matters. So I'm putting you in the tremendous hands of Alyssa, Ellie, and Stuart. Appreciate the fact that you guys are here. Let's learn. I'll turn it over to Alyssa. Thank you.
And I'm actually going to turn it over to Ellie so that she can go ahead and get us started working through the presentation. Just one thing to note, we do have polling questions for purposes of CLE credit. Those polling questions are going to come at the end of the presentation. So you're going to have to spend some time with us, but go ahead and hold on until those polling questions appear. They'll be after Stuart's portion of the presentation.
Brilliant. Well, thank you both for the introductions, and thank you very much for welcoming to your webinar. We're very happy to be here, and thank you to everybody who's joined to listen to us. As Shaw mentioned in the introductions, Ellie and myself are lawyers at Pinsent Masons. I appreciate there may be some on the call who don't know who Pinsent Masons are. We are a law firm, and we've got a really fantastic geographic coverage if you draw a line down the Atlantic Ocean and look east of that. So we don't work in the US, but we work very closely with the Constangy team, and delighted to partner with them on this webinar. Ellie and I both sit within our cyber team, and we've been asked to give the opportunity to talk through our annual cyber report. And it's a report that we prepare every year, including the title. We started this about 6 years ago when the GDPR came into force, and have been updating it every year. And we pull out all the stats and themes of the incidents that we see, as well as considering some key trends that operate in our jurisdictions. And we're going to focus on the three main areas on this session today. The first of which I'll hand over to Ellie in a minute to talk through a case review of our key matters last year. We'll then pick up a session on supply chain management, some of the things to think about when it comes to supply chain cyber risk. And then finally, at the end, I'm going to do a bit of a regulatory wrap up of some of the key regulatory developments when it comes to cybersecurity, drawing upon the expertise of our international cyber team. So we hope you enjoy this session and find the report of interest. And I'll hand over to Ellie now to kick off.
Brilliant, thanks Stu, and it's lovely to be joining the Constangy team for this presentation. So I'm going to jump straight in with our analysis of the matters handled during 2024, which I hope will provide some insight into the UK cyber market and what we see on this side of the pond. I'm in charge of the slides, so no pressure. In terms of the first stat that I want to show you then, it comes back to incident type. And ransomware, you'll see what we've included is our year-on-year stats, just so you've got the comparison, because we think that that helps paint the picture for what we handled last year. But ransomware, you'll see, was down slightly from 58% to 42%, but it's still very prevalent. As a general observation, we saw a far broader range of cyber matters in 2024 than in previous years, so far more credential stuffing, all sorts of different, interesting things that were coming across our desk. We also saw a notable uptick in business email compromise from only 5% of our incidents in 2023 to 26% last year. Now, I think that's reflective of the fact that actually we launched what I believe is the UK's first fixed fee legal fee for BEC. So many of you on this call will be aware that a lot of the big forensic providers will fix their fees, but so will we. But I think we are the only UK firm. And inevitably what happens when people get wind of that, they send you their BEC. So that probably is indicative of that. Moving on then to data exfiltration, you'll see that this has shifted year on year. So 83% of our ransomware cases last year involved exfiltration, so where the data is stolen from the client's systems. And that is significantly higher than in 2023, where it was only 51%. But in reality, 83% is more in line with what I'd expect, as we're seeing more breaches with exfiltration only and no encryption. And possibly that's because many of the clients we're working with have better backups and enhanced security generally. Now, this next slide is a new metric for us, and it's not something I can give you the year-on-year change. But you'll see what we were starting to do is track the threat actor groups that we were working on breaches related to. And what you can see from this is Akira was our most prevalent threat actor group last year. But again, we saw a far broader range of threat actors than in previous years, which links back to what we've talked about previously in our annual reports. If you take the time to look back at what we've said previously around the fragmentation of threat actor groups. And we really saw that coming to fruition last year, where there was a breakup of some of the big threat actor groups previously, and then we saw them coming back up in smaller fragmented groups. And what that meant is we ended up in a position where around a fifth of our cases, we didn't know who the threat actor was, and that makes responding to a breach more challenging. Now, for Q1 2025, the most prevalent threat actor by some distance has been Medusa, who are typically quite aggressive and use social media to publicise victims' names, for example. They are a more prevalent threat actor group in the UK, and we are aware of a lot of law enforcement interest in Medusa in particular. So moving on then to ransom demands and insured matters, a number of our insurer clients asked us what percentage of our matters are insured and whether having insurance impacts the desire to pay a ransom. Now, historically, I would have said, no, I don't think it does impact the desire to pay a ransom, because I think it's still fundamentally a commercial business decision for the insured itself. But I felt that perhaps it influenced the desire to enter into negotiations. But our stats paint a slightly different picture. And just to put them in context, you'll see that 78% of our matters last year were insured breaches, so where there was an insurer sitting behind the client. 25% of our clients paid the ransom, but 100% of the clients who paid had insurance. And that really tells you something, doesn't it, around how much having insurance does influence the desire or the decision to pay potentially. Now, you'll also see on this slide that the highest demand was 70 million. That was a bit of an outlier. That was on a big travel sector breach that I worked on, and actually Alyssa's been supporting us on for the US elements. And the lowest was pretty small at only 40,000. And when it's as low as $40,000, it does sometimes leave the client asking, why wouldn't I pay? Alyssa, I think it's probably interesting to bring you in at that point. Historically, the stats that I've heard used to compare the US and UK market in terms of percentage of clients that pay the ransom were roughly 40% of clients in the US would pay versus 10% in the UK. But we're now sitting somewhere in the middle of that, as you can see from this slide, with a greater willingness to pay, and it's moved towards roughly a quarter of our breaches. And I just wonder how that sits as against your client base and where that, what that comparison is for the US market.
You know, it's interesting. A lot of our clients now are shying away from payment, I think in part because of our guidance, which is number one, you're still paying criminals. So even if there is a business reason to pay, and certainly it's necessary if you need a decryption key to unlock your data, you're paying criminals and you're relying on the promise of criminals. And so, you know, those criminals may say, we're not going to post your data, we're going to provide a key, whatever the promises are. Some of those promises, like providing a key, are easier to hold criminals to, or at least justify a payment for, because we have reason to believe that they'll actually provide a key, in exchange for payment. Much harder in the area of data suppression. And so I think we are hopefully seeing a decrease in the ransoms being paid, in part because of that conversation, in part, as you mentioned, because our clients are catching up and they are able to rely on more viable backups. And as a result of that, we're seeing threat actors come in and only exfiltrate data and not encrypt environments. The other factor that we have here, I think a little bit more in the US than the UK, is our litigation atmosphere. Over on this side of the pond, we like to sue each other a little bit more, maybe than would be normal practice in the UK or in larger Europe. And the reality is that most insurance policies, or many insurance policies, I should say, have the same limit of liability, both for third-party and first-party costs. And so we encourage our clients, especially when there's a large notification population, to preserve resources for those litigations, to defend themselves, and hopefully to settle those litigations so that they don't have to go all the way to a jury trial or whatever the case may be. And so we've got sort of different arguments over here, but I would suspect that our amount of ransoms being paid track the percentages that you've provided.
That's really interesting. Thanks, Alyssa. So then moving on, if I can make the slides move on, there we go, to sector, client sector. Typically and historically, we would have said it would be the FS sector as the most prevalent sector we deal with in the cyberspace. But actually last year, when we looked at our statistics, almost a third of our matters were technology related. But as a firm, we have a huge technology practice. So perhaps it's less surprising than it might seem. The next most impacted sectors, as you can see from the slide, were professional services, healthcare and construction. And I certainly spent a lot of my time on legal and healthcare sector breaches last year. And actually they're continuing to be quite prevalent this year. We also, as a firm, have a large construction client base. And so again, that slightly skews those statistics, but you get a sense of the types of sector that we play well in and that we see coming across our desks. Then moving on to root cause, the most common root cause in 2024 for us was exploitation of a vulnerability at almost a quarter of our matters, closely followed by phishing and then a failure to patch. Now, in the UK, it's never great to have to tell the regulator that the cause was a failure to patch, and it's something that will raise questions from the regulator and potentially a slap on the wrist, if not worse. But sometimes patching isn't the complete picture. And on one matter I've got currently, there was a recommendation to patch a critical known vulnerability that was accompanied with an advisory to rotate passwords. Now, the client did what they were supposed to insofar as they applied the patch, albeit after a slight delay, but they failed to rotate technician account passwords. Had they done so, the attack would have been thwarted. And it is a bit of a salutary tale to check if additional steps are required beyond simply applying the patch. And these were steps that had been provided by the software company that had the vulnerability, and they specifically said, here's the patch, but also take these additional steps. Moving on then to looking at our regulator and what we see. You'll see here we've talked about how, as a proportion of our cases, how many of our clients notified. And you can see that it's broadly consistent with our 2023 statistics at roughly 54% of our clients electing to notify. It really represents a bit of a stabilization in the number of clients reporting to the ICO, because we'd previously seen a year-on-year decrease. And Alyssa, again, I'm quite interested to find out how that compares to the US in terms of the percentage of clients who notify your regulators, your attorney generals, for example.
So in the US, it all depends on the state law in which the impacted individuals reside. And as I'm sure folks on the call are aware, that is what triggers notification to the state attorneys general. We are far more decentralized. And so notifications maybe to the Indiana AG, which is the most problematic if only one individual in Indiana needs to be notified, or if individuals reside in Pennsylvania, you up until very recently, you didn't need to notify, though that has shifted a little bit. So it sort of depends on the location of the client, and what the basis of the data is. If it's employees, far more likely that it's going to be pretty localized to where the client is located, unless it's data dating back many, many years, and then you've got a bunch of former employees who may have moved all over the United States. Typically, there's at least one or two regulators that do need to be notified in an incident. For us, the seriousness of that notification depends on which regulator you're notifying in that moment. On top of our state laws, we then also have federal laws, so there may be notification to banking regulators, to OCR for purposes of HIPAA. So and there it depends on the sector. So financial services and healthcare, obviously, and then shortly, which we'll talk about later in the presentation, critical infrastructure. Those areas have more notification requirements than some of the other clients that we represent.
Okay, that's interesting as well. So then, it's interesting to hear how this compares with you, but what we've also done is tracked the queries by theme that we received from the ICO, our data protection regulator. And you can see that last year, the nature of affected data, the data subjects themselves, the root cause and any evidence of detriment were a key focus for the ICO. Now, generally, we found that they were asking for far greater detail far earlier than in previous breaches. So in previous years, they're going far deeper, far quicker. But on the flip side of that, we've seen far more closure notices being issued far sooner than you might expect. And one of the things we sometimes see is that they are closing files down before data mining is even commenced. So before that very time-intensive and potentially costly exercise of looking through the affected data has started. And sometimes what that can mean is that the client looks at you as the lawyer and says, but the ICO is satisfied that there's no breach of the UK GDPR, no enforcement action is going to be taken against us, and therefore why do I need to continue with this expensive and time-consuming exercise? And the answer is because you are still expected to fulfill your data protection obligations, and it's quite interesting to see how that discussion can play out. And then one more on the ICO. What we've done is just summarize some sort of additional statistics around what we see in terms of the length of investigation, for example. So 35 days is the average length of the ICO investigation, which again is broadly consistent with previous years. It can be quite quick dealing with the ICO. We sometimes get ones that are sort of particularly quick. I think the quickest I've had is it was closed after 2 days, but sometimes they can be quite protracted. Now, we've also started tracking the percentage of breaches resulting in notifications to non-data protection regulators. So for us, the solicitor's regulatory authority, if it's a law firm breach, the FCA, so the additional regulators that we might have to tell, which you've sort of touched on, Alyssa, in talking about the additional regulators you might need to notify. And that's 14%. We only started tracking that last year, so again, we can't give you a year-on-year change, but you can see that the non-data protection regulators are playing a relevant part in relation to cyber incidents. We've touched a little bit on data mining. 22% of our cases resulted in data mining. We often now find that we're doing the data mining ourselves. We have a very cost-effective in-house solution, and it makes sense for the lawyers who've led the breach to also be leading that data mining exercise. Data subject notifications to individuals were carried out in 20% of cases. You can see that that's lower than the number of cases that were notified to the ICO, or data protection regulator. And the reason for that is that the threshold for notifying individuals is higher than that which you apply for notifying the regulator. To notify the regulator here, the test is that there's been a personal data breach and there's a risk of harm. Now, for notifying individuals, there needs to be a high risk of harm. So it follows that the percentage of notifications resulting in data subject notifications should be lower. Some litigation stats there, which comes back again to Alyssa's talked a little bit about the litigation landscape in the US. And I think this will paint quite an interesting contrasting picture. So we continue to see a significant decrease in post-breach litigation in the UK market. Only one matter in 2024 resulted in threatened claims by individuals, and none of those claims litigated. Three matters gave rise to threatened claims against managed service providers. And there has generally been an increase in threatened claims from victims of payment diversion fraud resulting from business email compromise. Now, winding the clock forward to what we've seen in Q1 so far this year, I would say there has been an uptick in the contractual breach claims that are following a breach so far. So a number of my active cyber matters have got third-party litigation brewing in the background. So these are not the individual compensation claims that we historically used to see a lot of. These are the big disputes in relation to failures to prevent a cyber attack, for example. So it is an interesting contrast to your litigation landscape.
In just on the litigation point, in the U.S., litigation is really tied to, private litigation rather, is really tied to the number of individuals who are notified of an incident because of the class action threat. And so the more individuals who are notified, the more likely a litigation is. Though at this point, we're seeing class actions down to 1,500 or 1,000 individuals. But it's one of the reasons why our team always tries to fight out of notification. And so if there are reasonable grounds to avoid sending out notification letters to consumers, we're certainly going to lean on those to decrease the size of the class. I wonder if there's something similar across the pond as to how you might be able to anticipate a litigation tied back to a certain sector, or as an example, healthcare organizations are far more likely in the US to face a litigation than other sectors.
I mean, I think there are sort of risk buckets, as it were. So former employees will always be the ones that jump up and down the most, typically, because there's a question as to why you're still holding their data when they left your business 10, 15 years ago, which is a fair question. And also they've got no loyalty to you as an organization. So we often see those are the individuals who will jump up and down the most, as I say. In terms of sectors, yes, I completely agree. Healthcare related is going to pique more interest, but we still have an underlying issue in the UK that in order to bring a compensation claim, you need to show genuine harm. So there needs to be financial damage or genuine mental distress. And actually the threshold for proving those things is not easy to overcome in the way that it used to be. So we used to have quite a lot of these individual compensation claims. I had one matter a few years ago where we had issued only 3,000 notifications, but we received 1,000 individual compensation claims off the back of it. Now, these are not group mass action litigation. They are individual claim forms, individual letters of action, and they can be quite costly to deal with. But that has really shifted. So wind it forward to maybe last year, issued 7,500 notifications, and I think I received 8 complaints, pre-action correspondence, none of them litigated. We didn't pay a penny to any of those claimants. So that individual compensation claim market is fundamentally different to the US mass claims market, where I know you and I have had those discussions on some of the matters we've worked on together, where you explain that one of the risks with issuing the notifications, as you've just said, is you end up in a situation where there's claims farming, and you have to keep that in mind. And that is a different color to what we see over here. So then just moving on to the second section of our presentation, and before I hand over to Stu, third-party risk and the ongoing challenges that we see. Just bringing up this slide, probably some of these third-party breaches will be ones you're familiar with from the US market. From our experience in talking to clients and managing cyber incidents last year and beyond, third-party cyber risk remained a critical concern, a board-level concern for organisations. And the nature of our connected global digital landscape has meant that businesses have increased their reliance on external vendors and partners. And inevitably, that reliance can present a risk. Where external vendors and partners experience a cybersecurity incident, this can have significant ramifications on the supply chain. And last year saw several high-profile incidents highlighting that ongoing need for businesses to implement robust third-party risk management strategies. Now, as I said, I expect you'll be familiar with some of these, probably Change Healthcare, CDK, National Public Data, but you may be less aware of Blue Yonder, Synovis, TfL, and MOD. What I'm trying to do is select quite a few different examples to highlight the broad range of risks that can be caused as a result of supply chain breaches, rather than repeat endless stories. This is another supply chain breach. Now, they are all supply chain breaches, but they've got different facets that make them useful to compare. So picking off Change Healthcare as the first one, it was one of the most severe breaches of the year, and it really had a huge impact. It acts as a clearinghouse for 15 billion medical claims each year. And in February last year, the threat actor group known as Black Cat used compromised credentials to access a Citrix portal, allowing them to infiltrate Change Healthcare's system and steal around 6 terabytes of sensitive information. Now, the breach affected approximately 100 million individuals, making it one of the largest healthcare data breaches in history. And the cause has been attributed to a lack of multi-factor authentication on a legacy server. And the attack severely disrupted Change Healthcare's operations, particularly its billing services, which took several months to fully restore. The incident had severe knock-on for hospitals, pharmacies, and medical practices across the US, so its supply chain, and the nature of the data involved in the incident, being medical data, prompted investigations into the company's compliance with HIPAA regulations, and it highlighted the need for stronger cybersecurity measures in the healthcare sector. Now, some of what I've just said may not be new to some of the participants in this webinar, but interestingly, pulling this across the pond again, in the UK today, the data protection regulator, the ICO, has issued a fine of £3 million against a National Health Service software provider called Advanced Computer Software Group for a breach where hackers gained access to patients' phone numbers and medical records of only around 90,000 people, as well as details of how to gain entry to the homes of 890 people receiving care at home. And the regulator, in its monetary penalty notice, has expressly stated that Advance should have had multi-factor authentication in place across all of its estate, and it was criticised for failings in this regard. And off the back of this incident last year, NHS England, which sort of manages the NHS service in the UK, the National Health Service, they wrote to all national health providers and said, we expect you to have MFA in place. And that was as a direct result of this. So you can see that MFA caused a problem in Change Healthcare, and so it caused a problem in Advanced Computer Software Group. And the ICO has made it quite clear that they just have a basic expectation that you have the MFA in place. Moving on to CDK Global. In June last year, CDK, a major provider of car dealership management systems in the US, experienced a significant cyber attack from threat actor group Blacksuit that led to a national shutdown of its services. The attack disrupted operations for around 15,000 car dealerships, forcing many to revert to manual processes for transactions. CDK shut down most of its systems as a precaution, and the operational impact on dealerships included an inability to access dealer management systems, disruptions in tracking and ordering car parts, as well as difficulties in conducting new sales and offering finance. Now, what I'm about to say may not be a sentence I ever thought I'd utter, but actually car dealership breaches are fascinating to advise on. There's a huge amount of connectivity between dealers and the car brands or manufacturers to allow the dealers to know what stock is available and where. And when a dealership suffers a breach, and I've acted on a number of these type of instances, typically what happens is the car brands pull the drawbridge up to their systems, leaving the dealership blind as to what stock can be sold. And it's not until a series of assurances can be given that the drawbridge comes back down and connections are re-established. Now, interestingly, with CDK, it was reported, although not confirmed, that they paid a fairly chunky ransom of $25 million. National public data then. So this moves forward to August last year. National public data was, and I will explain why I say was an online background check and fraud prevention service that confirmed a massive data breach exposing 2.9 billion records. The breach, which began with unauthorized access in December 2023, led to the leak of sensitive information in April last year, so a few months later, by the threat actor group US DoD. The incident purportedly cost over $500 billion and raised significant concerns about identity theft and fraud, given the nature of the data affected. Now, National Public Data has filed for bankruptcy and it has a closure notice still live on its website. Occasionally, we do have clients that go into collapse as a consequence of cyber incidents, and it's always, of course, very depressing when this happens. Now, Blue Yonder, again, winding forward a little bit, November 2024, they are a prominent supply chain management software provider, and they experienced a severe ransomware attack that disrupted services. The incident began on the 21st of November and affected their ability to manage service-hosted environments, causing significant operational challenges for its clients, including household names like Starbucks, Sainsbury's, and Morrison's. Now, interestingly, This breach popped back up into the news this morning when I was reading the Times, perfectly timed for this webinar, because Morrison's has expressly referenced the incident as having hampered its financial turnaround. Morrison's, I don't know if you have it in the US, but it's a large supermarket brand here in the UK. And the attack led to delays in the supply chain for many, including Morrison's, impacting the availability of goods on supermarket shelves. I promised to talk about ones that you were probably less aware of, and Synovis, back in June again last year, the UK's National Health Service declared a critical incident, and it's quite rare for that to happen in relation to a provider in the way that this is going to turn out to be. Its pathology services provider had fallen victim to a ransomware attack, and the incident was highly publicised here in the UK. I don't know whether it hit the US press, but it was considered to have a direct impact to human life and well-being. Blood transfusions, test results, operations related to cancer treatments, and even C-sections had to be rescheduled. Over 1,100 elective procedures and more than 2,008 outpatient appointments across the major London hospitals had to be postponed. And the attackers stole and leaked 400 gigabytes worth of sensitive data and attempted to extort money from Synovis. They allegedly demanded 50 million, and upon non-payment, they dumped the data online. Again, the attack underscored the pressing need for robust cybersecurity protocols within the National Health Service supply chain to safeguard patient data and maintain uninterrupted healthcare services. Two more from me. Transport for London. So in September last year, this is the local government body responsible for most public transport in the UK, including the Tube in London, which many will be aware of. And they experienced, in London, the name is on the tin, experienced a sophisticated cyber attack that disrupted services. And the greatest impact was on differently abled passengers who relied on TfL's dial-a-ride service, yet again impacting the huge impact cyber attacks can have on daily life. Now, initially, TfL believed that no data had been compromised. However, further investigation revealed the extent of the breach, and the attack had allegedly compromised the personal data of approximately 5,000 customers, including information such as home addresses and banking details. Now, this turned out not to be one of the big typical threat actor groups that we normally deal with. It was a 17-year-old individual who was confirmed as the perpetrator of the attack. Concerned that this could be a full-blown ransomware attack, the IT security teams at TfL took action by shutting down and restricting access to several systems to contain the damage. However, unfortunately, this resulted in significant operational disruption and financial loss. And TfL has subsequently reported that the incident cost them around £30 million. So the cyber attack on TfL serves as yet another reminder of the critical importance of safeguarding critical national infrastructure against these digital threats. And then the final example, before I move on to some practical points, and then I'll hand over to Stu, the Ministry of Defence. So in May last year, the UK's Ministry of Defence experienced a significant data breach where a contractor-operated payroll system was compromised by a cyber attack. And the system contained personal data, including names, bank details, and in some cases, home addresses of approximately 270,000 current and former UK military personnel. And Defence Secretary Grant Shapps informed Parliament that the attack was likely orchestrated by a malign actor. There were suggestions of involvement from a potential foreign state, but while the government didn't officially attribute the breach to a specific nation, multiple media outlets reported suspicions of Chinese involvement. Again, I don't know if this made its way across the pond, but the incident really underscored the importance of robust cybersecurity measures. I'm saying the same thing here, particularly concerning third-party service providers. And vulnerabilities within the supply chain were yet again exploited to catalyse far-reaching implications for national security in this instance. So I hope from those 7 examples, you can see how many different parts of different sectors can be affected by these supply chain breaches. And so just some final points from me before I hand over to Stu around the importance of third-party risk management. So the incidents I've just highlighted serve as a reminder of the vulnerabilities inherent in third-party relationships. And our team has seen a marked increase in the number of clients seeking advice on operational resilience in respect of cyber incidents affecting their supply chain. So as opposed to just affecting them direct. Some of the conversations we've been having with our clients to direct how best to understand risk in the supply chain have focused on the elements that I put up on the slide. So regular reviews and mapping. We've been recommending that clients conduct thorough evaluations of third-party vendors to identify potential risks. And often a mapping exercise is useful to understand the supply chain and the types of subcontractors involved and what they do. This can be challenging, especially when dealing with suppliers who offer services to multiple customers, as there may be a limit as to what they're willing to tell you and what degree of objection rights you have. Contractual terms. Contracts can be a useful tool to manage risk. From a personal data perspective, clients can think carefully about the operational impact of the terms in place. For example, to ensure controller processor roles, we have that differentiation in the UK, are appropriately designated within the contract to avoid any confusion about responsibility for regulatory reporting. And practically, we advise clients to think about what the appropriate trigger for personal data breach notification is. And we sometimes see that those clauses are drafted quite broadly. And importantly, whether you have any tools within the contract to assist in seeking information about an incident from your supply chain. We frequently run into challenges in getting up-to-date information from suppliers on behalf of clients when we're advising an impacted third party on the breach of one of their supply chain parties. So issues that crop up in terms of understanding whether it's contained, even what data has been affected, whether it's data relating to your client. And in many of the examples I've mentioned above, the customers were immediately and significantly negatively affected when systems were taken offline by the supplier in response to the incident. Incident response plans, then developing robust plans to respond to breaches swiftly and effectively, including those affecting third-party vendors. Now, sometimes what we see are very beautifully drafted 100-page incident response plans. They are so complicated that they do not get opened in the face of a breach, or worse still, they're sitting on a system that cannot be accessed in a face of a breach. So something brief and succinct is definitely my recommendation. Continuous monitoring, implementing ongoing monitoring of third-party security practices to ensure compliance with industry standards. And then finally, cyber simulations, running cyber exercises which simulate third-party cyber incidents to help with readiness to such situations. Organisations really should have regular fire drills and tabletop exercises to prepare staff to update data security protocols. And we've seen a marked increase following incidents around what happened to Capita and the Davey's group in the UK, in clients seeking to run these breaches where they're simulating a member of their supply chain being hit by a cyber attack, as opposed to them themselves being compromised. So as cyber threats continue to evolve, the importance of securing the supply chain cannot be overstated. And I hope the examples I've given just now highlight that point. Organisations that prioritise third-party risk management will inevitably be better positioned to protect their data and manage operational continuity in the face of potential breaches. And by learning from these incidents and implementing the proactive measures I've just talked about, organisations can enhance their resilience against future cyber threats in their supply chain. Alyssa, is there anything you want to add before we hand over to Stu for his section?
One point on the supply chain events, and I'll just mention Power School, which eked in at the end of 2024. I think from an American perspective, and this aligns with what you were mentioning, all of these supply chain events are so significantly different, and it makes it really difficult to plan for them and to sort of underwrite to them for those who are underwriters on the line. Change obviously had incredible impact to protected health information, which has federal regulations that apply to it in addition to state. PDK, we were told, didn't have any impact to information, so was a significant lift in terms of business interruption, but was not a big notification effort, so to speak. And then Power School was somewhere in between. So Power School was an incident where there were compromised credentials to a customer support portal that Power School had that allowed a threat actor to gain access to thousands of student information systems belonging to school organizations, so school districts and individual schools. The issue there is that the impact data depended upon how those different schools used the system. So for some, it was data belonging to individuals back to the 1990s. For some, it was data that was only current as of today. For some, there were impacted social security numbers. For some, there were not, and it was just student grades and attendance records and things like that. And then the patchwork of laws that we have in the United States also applied differently. And so obviously the state data breach notification statutes kicked in where there were, for example, social security numbers impacted. We had FERPA issues, which is a federal law We also have certain states that have student-specific data privacy statutes, and so we had to navigate the requirements of those laws. So I think the issue here is that each of these incidents is incredibly different, but the baseline is the same, which is, and I'm glad we're staring at the slide that we are. It is incredibly important to think about who has access to a company's data and what the obligations of that third party are in the context of an incident occurring, and that's all incredibly important. In terms of contract reviews and making sure that there are other ways to shift risk to those vendors that you're working with.
Brilliant. Thanks, Alyssa. Stu, I think that means it's your turn.
Thank you very much, Ellie. Thanks, Alyssa. So the third and final section of this webinar wants to pick up on the global cyber regulatory landscape. And I think just the phraseology you used there, Alyssa, in terms of that patchwork of laws, I think we're increasingly seeing a patchwork of regulation across much of the world. And so what I hope to do in the next sort of 15 minutes or so is give an overview of some of the regulatory changes that have happened in the past year or so or are on the horizon for this coming year. And I want to do that by looking just on the next slide at our Pinsent Masons office network, Ellie. If we could just move on to the next slide. And that, I mentioned this at the very beginning, we've got a fantastic global network up to the east of the Atlantic. So lots of offices in Europe, Middle East, Asia Pacific, and most recently an acquisition at the middle part of last year in Australia. And what I like to do is we use the input and the expertise of our colleagues around the world to identify the key regulatory changes in their jurisdiction. We've pulled that together and included it in our annual report. And I'm going to draw upon this map to identify those changes by four main themes. And those themes on the next slide are looking at some of the proposals and changes around ransomware. We've already talked about ransomware as a topic in the first of our sections. I want to talk about the stricter cyber requirements for connected devices, pick up data protection privacy legislation. We talked about that quite a bit, but some changes there. And then finally focus on cyber resilience laws, particularly in critical national infrastructure. And although the first of those is a bit of an outlier, but unique, the second, third, and fourth increasingly impose regulations on organizations across different sectors. And therefore, I hope would be of interest to those on the call that have got a global footprint or those who act as insurers or brokers for global organizations. So, pick up the first of those themes is ransomware on the next slide. And I wanted to just talk about a couple of proposed changes. Now, nothing in the world of cyber stands still for very long, and just as we were finalizing our annual report at the tail end of last year, there was a new Cybersecurity Act in Australia. And it does various things. I'm going to pick up on the Cybersecurity Act in a minute in a different context. But one thing it does is groundbreaking law is to impose an obligation for private sector entities to report a ransom demand. Now, there are certain thresholds that need to be met. Those organizations need to either have a turnover of more than 3 million Australian dollars or act within certain critical infrastructure assets. But there is therefore an obligation to report ransomware payments in Australia. And then even more recently, at the beginning of this year, we've got some proposals in the UK. They released mid-January, which was a day or so before we launched our report. So sort of very hot off the press. Those proposals are described as by our Home Office as world leading, and they comprise three proposals. The first limb is a targeted ban on ransomware payments for all public sector bodies. Now, at the moment in the UK, there is some sort of soft guidance or guidance that central government needs to abide by, meaning that central government can't make a ransom payment. But this proposal will extend that out to local government, including schools, trusts, NHS trusts, and local government organisations, as well as the owners and operators of critical national infrastructure that is regulated in the UK. And the rationale for that is, as described by the consultation, we believe that one of the most effective ways of preventing ransomware attacks is to ensure that the criminal gangs looking to target our essential agencies and infrastructure know they will make no money from doing so. So the proposal is, and this is a consultation proposal that's currently out to get responses from all across society. And now, speaking with those who operate public sector assets and critical national infrastructure, I think there are probably some concerns about how that will work in practice in the event that they were the victim of a ransomware attack and had no other option, or they were just targeted not because they were critical national infrastructure, but just because they happened to be unlucky, in the same way that any private sector organisation may have been hit. So it'd be interesting to see how the government responds to any concerns flagged at that proposal stage, but certainly a bold proposal. The second limb is a payment prevention regime, and this applies to all sectors, and whether they're private sectors or public sector organisations, that require any victim of ransomware to engage with authorities, report their intention to make a ransomware payment before paying any money over to the criminals responsible. And so what that introduces is effectively a gateway, effectively seeking permission of the government to make a ransomware payment, which I think probably of all the three proposals is the most contentious, because there's some concerns raised about how that will work in practice, whether the government department charged with this will have the resources to do that in a timely manner. As many on the call will know, that's obviously going to be a time-pressured and urgent decision. So building in a approval step, how is that going to work in practice, and against what criteria is that government department going to judge whether it's a good thing or bad thing to make the payment. And then the third proposal perhaps is less contentious, but includes a incident reporting regime, which could be society-wide or linked to certain thresholds, but requiring any organisation that has been the subject of a ransom demand, regardless of whether they paid it or not, to report that. I think that's effectively a sort of data gathering exercise. So certainly bold proposals. It remains to be seen how they, if at all, are introduced in the coming months ahead. Before I move on to the next topic, I don't know, Alyssa, if you want to sort of come in and sort of compare and contrast the position in the US at the moment.
Sure. So on the ransomware payment front in the US, there have been a number of laws introduced at the federal level seeking to either prohibit ransomware payments outright or require reporting of ransom payments above a certain amount, as an example. There are, I think, 3 at this point pending currently. Candidly, none have really gotten off the ground. So it's an idea that's been talked about for a long time, but hasn't grown any legs, so to speak. Remains to be seen what occurs there. On the state level, there are 2 states, North Carolina and Florida at this point, that I'm aware of, that ban state and local governments from making ransom payments. Similarly, other states have proposed legislation or sort of talked about banning ransom payments moving forward, but that has not come to fruition yet. I do expect that there will be additional states, at least with respect to public agencies, making determinations that ransoms can't be paid. From our perspective as a team, we are reporting all of our ransom payments to the FBI. So that is a step that we take when our clients seek to make a ransom payment. But there is not, aside from that, a process requiring ransom payments to be reported or ransom payments to be banned. The one thing I should note is once our CCPA Act is finalized, and that's likely to come online and be in effect in early 2026, there will be obligations for entities in certain critical infrastructure sectors to make reports of any ransom payments, but there's not discussion at this point of banning those ransom payments.
So I think probably, yeah, one to watch and clearly one to keep an eye on for those that need to consider making sure their backups are viable and all the stuff that we know about when it comes to doing ransom demands. So we'll move on to the second pillar on the next slide, which talks about sort of connected devices and Internet of Things. And on the first review, you might ask, well, how is this going to be relevant to my organization? Well, some of the changes are broad in nature, and they require a response and a reporting obligation if there are any vulnerabilities identified with those devices. And we're seeing increasing regulation around the world in this space. So the same Cybersecurity Act in Australia that I mentioned requires new minimum security standards for a whole host of connected devices. There's been a lot going on in Singapore. Last year, there's a focus on enhancing the security of connected devices and new guidance issued to require certain security features to be built in. Close to home in the UK, last year we had the Product Security and Telecommunications Infrastructure Act, the PSTI, which required all connected devices placed in the market to comply with certain cybersecurity requirements, introducing protections for consumers against hacking and cyber attacks. And then probably the one that certainly is keeping us the busiest at the moment is the EU's Cyber Resilience Act, which is going to come into law mid-to November, comes into force next year and the year after. And it requires all manufacturers, importers, distributors to ensure security standards. And here we're working with a number of clients based in the US who import into the EU, have connected devices, devices that connect to the internet, and that is defined in a very broad way under the Act, and requiring them to already start to think about their compliance program for what their products will look like next year and the year after, and making sure that they require with those minimum standards. And again, thinking about that in the world of incident response, a lot of those new regulations, such as the CRA, require companies to report active exploited vulnerabilities or severe incidents affecting their products within tight timescales, so not later than 24 hours or 72 hours for a complete notification. And we've been advising a wide range of organizations in this space, including manufacturers of tech hardware, home speaker systems, mining equipment, musical instruments, and so on. So again, a regulatory change theme around the world, and one to definitely keep an eye on if you are in the product manufacturing space. So moving on then to the next slide, if we could, Ellie. I want to talk about privacy legislation quite quickly. I've put in a slide there, which is a reminder for those who might need a refresher of the provisions of the GDPR when it comes to incident reporting. Ellie's covered those and the key tests that apply in the UK and the EU, and certainly many other jurisdictions have similar provisions modelled on the GDPR. So a reminder that when we're asked to advise on whether or not there is a notifiable incident, it is very much a risk-based assessment. There are no clear binary decisions as to whether certain data sets bring you in reporting obligations. This is an assessment as to the context, the type of data, and the likelihood of risk arising to relevant individuals that dictates whether there is a reporting obligation to the regulator or indeed to any individual. But this is again is a moving area. So on the next slide, please, Ellie, we're looking at changes to privacy legislation around the world. Starting in the UK, there is a new data use and access bill. This is our post-Brexit move away from the GDPR. Within our context, it probably isn't much of a move at all. It's going to very similarly follow the provisions of the GDPR. One slight change relates to rules around telecoms providers and providers of telecoms infrastructure, internet service providers. There's a separate regime in the UK called PECA, which is going to, under these proposals, align the reporting timescales. So we're at the same 72 hours for those type of breaches as we're familiar with for the GDPR. In the Middle East, there's a lot going on in terms of updates to personal data privacy regulation, and a lot of focus on data sovereignty and ensuring data stays in the right jurisdiction. And as I put on the slide, various changes being proposed to increase the powers of the privacy regulators in South Africa, Australia, and in Hong Kong. And then finally, and I am conscious of time, because I want to just spend a few minutes on the last of our themes, which is talking about new cyber laws that are coming around the world. And again, starting in Australia, that Cybersecurity Act I mentioned, well, that also imposes increased obligations on critical national infrastructure providers, and a similar focus in Singapore on critical national infrastructures and data center providers. So more obligations if you act in those sectors. In the UK, we have a new bill that is likely to come into force either later this year or early next. It's called the Cybersecurity Resilience Bill, and it tightens up the obligations for certain operators of essential services, operating the critical national infrastructure. So we're talking energy providers, transport providers, the NHS, water, and so on. So that's going to be particularly important for those organizations, but importantly also the supply chain that provides services to those regulated entities, and also likely to very significantly increase the number of technology digital service providers in scope. That'll be quite a significant change when that comes in, but we await the text of the bill. And finally, to wrap it up, the last couple of minutes at an EU level, those two boxes in orange are probably the two most important bits of cyber regulation currently on the pitch. DORA in the top right-hand corner is now in force, and it requires financial services companies and their critical providers to undertake a whole host of cyber resilience measures and attendant reporting obligations. But probably the broadest law of them all is NIS2, and in our report, our colleagues across all of our EU jurisdictions have summarised the progress of implementing this directive into their member state law. The punchline is it's been a very slow process, and most member states are behind in where they should be, and that is causing real difficulties for us and, more importantly, for our clients in knowing how to implement this directive. It's broad because if we move on to the final slide of this section, Ellie, it is a very broad piece of law. It covers a wide range of sectors, not just the critical national infrastructure sectors of energy, transport, and so on, but also postal services, waste management, a wide range of manufacturers, food distributors, digital providers and technology providers, and so on. It has an extraterritorial effect, so it will impact organizations based in the US that provide services into the EU, and it requires very significant obligations in terms of putting in place cybersecurity measures, supply chain resilience provisions, thinking back to our earlier topic, personal liability on management for infringements, very strict incident reporting obligations, and fines and enforcement measures for breach. And this is keeping us incredibly busy across our team and our wider European team in helping our organizations that we work with understand the scope of NIS2. And I think in the years to come, the reporting obligations in NIS2 are likely to keep us busy when it comes to thinking about how to advise our clients through a breach. And I want to stop there because I'm conscious of time. So thank you. They're the common themes, just in summary. Alyssa, over to you.
Yeah, and just real quick for the US side of the house, we have something similar called CIRSA that's pending right now. It's likely to take effect in early 2026. And in short, it's going to require entities of a certain size and I believe 16 critical infrastructure sectors to report incidents within a certain time period. Likely within 72 hours unless a ransom is to be paid, and then that will be within 24 hours. So similarly, there's increased focus on businesses in certain sectors and the information that they provide to the government, specifically the Cybersecurity and Infrastructure Agency. With that, I really appreciate everybody's time today. I appreciate the information shared by Ellie and Stu. Thank you guys so much for joining. Appreciative of you both and the partnership with Pinsent Masons. I'll turn it to our organizers for purposes of the polling questions. Go ahead and respond to those for CLE credit. We do this on a monthly basis, so I hope everybody can join us moving forward. Go ahead and answer those polling questions, and we will follow up with respect to CLE information. Thanks, everyone.
Thanks, everyone.
Thank you very much.